Welcome everyone to the program. Now, one of the major agenda of the Buhari government in the first term is the fight against corruption, and it appears that drive is still on today as the Vice President, Professor Yemi Osinbajo, is chairing a corruption summit in Abuja, the nation's capital. The event is expected to help discuss issues that will help consolidate on the fight against corruption. Last week, the Economic and Financial Crimes Commission, EFCC, says it has recovered over trillion naira illicit funds and stolen assets in the past 3.5 years. The Commission also says it has secured the conviction of 2 former governors, amongst others, who are serving jail terms owing to looting and citing of ghost projects. Now, Hope Democratic Party, they filed a motion seeking an order of the Presidential Election Tribunal restraining President Muhammadu Buhari from presenting himself to be sworn in on the 29th of May 2019. The party is also seeking an order restraining the Chief Justice of Nigeria from swearing in, administering the oath of office and oath of allegiance to the president. In a motion on notice made available to Channels Television, the party filed the motion on 6 grounds pursuant to Section 1, Subsection 2 of the 1999 Constitution as amended and under the jurisdiction of the tribunal. Some of the grounds of the application is that there is a pending petition challenging the election and return of President Buhari as the winner of the February 23rd presidential election. It also said the petition has been served on the president and pleadings have been exchanged. It continues to maintain that in spite of the pendency of the legal action against President Buhari, it has been making frantic efforts in preparation for his inauguration. The party also averred that the law is settled, that once a question of the validity of an election of any person is challenged, that person is not competent to take oath of office or assume the seat of power. Meanwhile, the counsel to President Buhari, the All Progressives Congress and the Independent National Electoral Commission, INEC, say they are yet to be served with the motion. Chairman of the tribunal adjourned to May the 22nd to hear all applications from the political party against the victory of President Buhari. Let's now speak to our correspondent who's covering proceedings for us, Amaka Okafor. She's on ground for us on that issue. And she's also covering several other issues, as we know, the Osun State. Okay.
When the Presidential Election Tribunal began its start for its inaugural sitting, the president of the appeal court, who is also presiding over the tribunal, adjourned to today to have the pre-hearing session of the petition filed by the Hope Democratic Party against the election of President Muhammadu Buhari on February the 23rd. Now, a pre-hearing session is a session where all applications emanating from a particular appeal are heard before the suit in the main. Now, one of the appeals filed by the Hope Democratic Party is an appeal seeking to restrain President Muhammadu Buhari from presenting himself to be sworn in as president on May 29, 2019. The Hope Democratic Party is also asking the tribunal to restrain the acting Justice of Nigeria from swearing in President Muhammadu Buhari or administering oath of office to him. According to them, there is a pending suit before the tribunal, and because of the pendency of that suit, the president ought not to present himself to be sworn in as president on May 29th. They also claim that it is settled in law that once the question of the validity of an election has been raised, such a person ought not to take that position or that state until that petition is done and dispensed with. However, when counsel to the Hope Democratic Party raised the application in court, the respondents in the case, which include the All Progressive Congress, the Independent National Electoral Commission, and President Muhammadu Buhari, all informed the court through their counsels that they had not been served. And because of that, the application is not ripe for hearing. And so the president of the appeal court is also presiding over the tribunal, adjourned hearing in that particular application to the 22nd of May 2019. 2019. And just as she was adjourning that particular application, counsel to the president, Mr. Wole Olanipekun, informed the tribunal that he has an application seeking to quash the petition of the Hope Democratic Party. But counsel to the Hope Democratic Party immediately told the tribunal that he will be opposing that particular application because the facts in the application are facts that touch on the petition and the case in the main, and it ought not to be heard at this time during the pre-hearing session. And having heard everybody, the presiding judge, who is also the president of the appeal court, adjourned to the 22nd of May to hear all the applications emanating from this suit filed by the Hope Democratic Party against President Muhammadu Buhari's victory at the 2019 presidential election. Now, just next door to the tribunal is another panel sitting on an appeal filed by Senator Ademola Adeleke challenging the judgment of a Buhari High Court, which held that he forged his West African School Living Certificate, which he submitted to INEC as part of requirements to participate in the governorship elections in Osun State in 2018. In fact, in his appeal, Senator Adeleke, through his counsel, told the tribunal that told the court that the lower court did not have jurisdiction to hear that particular appeal because it is sitting in Abuja, while the facts of the case happened said to have happened in Osun State, and so the court didn't have a territorial jurisdiction to hear the people who took him to court. He also told the court that through his counsel that the results submitted by WAEC to the court was the same as the results he submitted to INEC. According to him, the only difference was the format in which the results were sent in. He also told the court that INEC sent a ledger result while he sent in a certificate that was given to him, and that the facts on the certificate is the same as it is on the ledger submitted by WAEC. As such, the appeal court should quash the judgment of the lower court and uphold his appeal. But in opposing the application, the counsel to the respondents in this case told the court to dismiss the appeal by Senator Adeleke for lacking in merit. According to him, the issue before the court is the issue of forgery and not a election matter. After hearing both parties, the presiding judge adjourned to a date to be communicated to parties for judgment to be delivered in the appeal.
Many thanks, Amaka Okafo, there live for us on those two key issues, the appeal by Senator Adeleke, that's the governorship candidate of the People's Democratic Party, Osun State, and of course the appeal filed by the Hope Democratic Party stopping the inauguration of the president. Well, we have a legal expert to help us define some of the grey areas, especially on this motion seeking the order of the Presidential Election Tribunal to restrain President Buhari from presenting himself to be sworn in come May 29. And joining us in the studio is a legal practitioner, also the former second vice president of the NBA, Monday Bani. Thank you for joining us.
How are you?
Very well, thank you. So, I mean, seeing this, is this novel? We had this before in our 20 years of democracy.
Clearly novel. And parties can try as much as possible to be innovative in the pursuit of their claim. This is the first time I'm getting to hear about such an application in any election petition. I always know that petitioners pursue their substantive appeal to conclusion. But bringing an interlocutory application to now say, look, the person should not be sworn in, pending the determination of the petition has never taken place. So it's clearly novel. And I think that the respondent will file their counter.
We have a date that it's been adjourned to. Do they have time? What will happen?
Well, the court will accommodate it now. I'm sure they say they have not been served. I'm sure by today they should get service, and they should be able to respond to it timelessly. It's going to be an interesting, ruling from the court. As I said earlier, the allegation is that, look, if we don't do it, it will force upon the court the state of helplessness, But looking at precedent, we know of situation where governors who have been sworn in have been removed. by the court. I mean, somebody like Adam Oshemole, who happened to be the present chairman of APC, was a beneficiary of a court order in which somebody has already been sworn in, and the person was removed by the court. The same thing with Fayemi, who's currently the governor of Ekiti State. He was also a beneficiary of a situation where somebody has already taken his oath of office and the court had to remove him. So I don't know. Well, the court will come to a logical conclusion after hearing both parties in this novel application. We're developing our jurisprudence by the day, and maybe something contrary may come up from the court, and that will be very interesting and exciting.
A lot of people are also wondering, I mean, the motion on notice, they're saying they have 6 grounds on that. And there's also, they mentioned the, of course, pending petition challenging the election and the return of the president. And they've also copied the party, the APC, and also INEC. From their positions, well, what do you think will happen in the coming days? Well,
as I said earlier, it's going to be interesting. What we know is that parties, petitioners pursue their substantive, petition. If there is no compliance with the election of that particular person, the court will make a pronouncement that the person is, not properly elected, and then remove that person. But this is the first time such an interlocutory application is coming up and say, look, don't allow the CJN to swear in a candidate who has been declared a winner by INEC. Now, I have gone through the Electoral Act, because that is ground norm, and then, the Constitution and the Electoral Act, which is actually a legal instrument that has to do with electoral matters. Electoral matters are sui generis. It's a special type of matter. It's a special type of case. And so if you want to succeed in anything that has to do with electoral matters, you have to look at these 2 instruments. There is no such substantive provision in the Electoral Act that asks for this interlocutory application to be made. But they relied on Section 1, subsection 2 of the 1999 Constitution as amended. And I look at that particular provision. What does it say? An individual or group of persons cannot take over the administration of Nigeria except in accordance with the Constitution. Can that be the substantive law under which you can bring this interim interim application? Well, the court will, in the days ahead, make a pronouncement concerning this. But as I said earlier, our jurisprudence is developing, and people have to become more innovative in the pursuit of their claim. Maybe they're coming with this claim. Who knows what the court will come up with, and that will be interesting for us, But for me, if you want me to say, to air my opinion, I don't know.
Okay, we'll leave it at that. We'd like to thank you for joining us on the program. See what throws up in the coming days.